All right, welcome to our podcast. This is Vote on Purpose. I am Meredith. We have Brian with us today as well. Today we have the pleasure of talking with Judge Lora Cubbage. It's September 3rd. This is episode 6.
Yes, thank you, Judge Cubbage, for joining us and taking time out of your schedule. So we appreciate you for that.
Thank you, and I am honored to be with you.
Thanks. So we'll just kind of jump into, like I say, currently you're Superior Court Judge in Guilford County, correct?
Yes.
And then right now you're running for the North Carolina Court of Appeals. Is that seat 5?
Yes.
Perfect. So just jumping right into that, how does that background, being a Superior Court Judge, how does that parlay, or what skills do you take from being a Superior Court Judge to then a Court of Appeals Judge? How does that differ, or the roles differ?
The role, as a Superior Court Judge, I am what they call a trial court judge, and I am the highest level trial court judge in the state of North Carolina. The North Carolina Court of Appeals is the intermediate level appellate court. It's the second highest court in the state, but it's the first level of appellate court, with of course, the North Carolina Supreme Court being the highest level of appellate court. So to understand how I will segue from one to the other, you have to understand what the Court of Appeals does. So judges on the Court of Appeals, 15 judges, they sit in panels of 3, and they review cases not based on the facts of the case. But when someone appeals their case, the Court of Appeals is going to review cases based on what the judge in the lower court did wrong. Was there error of law applied, or was there error of procedure? Or they're going to review cases based on constitutionality. And most of those cases are going to come from something that the legislative branch has done or not done, or the executive branch has done or not done. And when you talk about just the general cases that come to the Court of Appeals, these cases are going to be 80% criminal cases, and those cases are going to come from the Superior Court level, which is where I currently serve. Your civil cases are going to come from both the Superior Court level as well as the District Court level, because cases in the District Court level regarding civil, which are going to be your family law cases, custody, child support, divorce, equitable distribution, and your juvenile delinquency cases. Mm-hmm. When those cases are appealed, they do not go to the Superior Court. They go directly to the North Carolina Court of Appeals.
Wow.
So what makes and then the rest of the civil cases, which are your business cases, your contract cases, those types of things, those are going to come directly from the Superior Court. And so the reason why my experience is so significant is because over 90% of cases that the Court of Appeals will hear are going to be cases that are coming from the Superior Court bench. Mm-hmm. And those are also going to be cases that have either been heard at the bench trial, which very rarely happens in Superior Court for criminal, but does sometimes happen in Superior Court for civil. But most of the cases are going to be trial cases where there has been a jury of 12 that has presided, and whoever is appealing the case, whether it be the state or the defendant or the plaintiff or the defendant in the civil case, is going to allege to the Court of Appeals, hey, the judge in the Superior Court did this wrong or that wrong, or the judge in the District Court for those civil cases did this wrong or that wrong.
Wow.
So the fact that I'm sorry.
Oh, yeah, no, I was just responding. Yeah, I'm sorry. Go ahead. Yeah.
So the fact that I have served as a District Court judge and a Superior Court judge, I have served in every trial court on the District and Superior Court level. I have served in the juvenile delinquency as well as DSS courts. I've served in the family law courts, all 3 of those courts, and I've served in criminal courts, and then as well as the general civil courts, like with your business things. Another thing that Superior Court judges do is you have to be specifically appointed by the Chief Justice of the North Carolina Supreme Court in order to preside over what we call 2.1 complex business cases. and in order to preside as a 3-judge panel over cases that involve constitutional issues. I have been appointed by the Chief Justice of the North Carolina Supreme Court to preside over both of those types of cases. Once those cases are heard on the Superior Court level, again, if they are appealed, they go to the North Carolina Court of Appeals. What the Court of Appeals is reviewing from the Superior Court or from the lower court, again, is did a judge let the evidence come into a trial that wasn't supposed to come in? Did the judge not let evidence come in that should have come in? Did the judge give the wrong jury instructions or give jury instructions that should not have been given? Did the judge make a comment during the course of the trial that could have prejudiced the jury? If it was a bench trial, did the judge apply the proper law to that case that should have been applied? Or, did the judge is the Court of Appeals going to decide that the judge used the law that wasn't applicable to the facts of that case? And depending on what the Court of Appeals decides, they can either remand the case for sentencing, resentencing, or a whole new trial, or say that, hey, judge, you've got to make findings of fact to let us know exactly what you saw in that trial down there that supports your ruling. When it comes to constitutional matters, one of the most notable cases that people will have heard coming from the Court of Appeals has been the voter ID law. And that started out as a 3-judge panel in Superior Court. Those judges decided that since the question of should we have an ID in order to vote in 2020 was on a ballot, and the popular vote said yes, we should have an ID, then it stands. The Superior Court judges said that's the law, it stands because North Carolina voted on it, and by the popular vote, the people, the citizens, and the voters said yes. It was then appealed by the NAACP and some other agencies, and it went to the Court of Appeal. What the Court of Appeal said was, so what happened here was they put this question, and it was merely just a question, yes or no question, on the ballot. Yes, the general population of the voters said yes, we should have an ID. But what happened after the voters said yes was the legislature went in and said, now that we've got a yes from our voters, now we're going to decide which IDs are valid and which IDs are not. So they made some valid, they said some were not valid. The Court of Appeals looked at it and said, yeah, you did do that, and yes, the legislature has the right to make up the criteria for which IDs are valid or not, but they don't have the right to pick the IDs that are mostly carried by a certain segment of the population as being non-valid. And the Court of Appeals found that certain segment was African American. And so they decided that the legislative branch did an unconstitutional thing, and they went in with precision and carved out IDs and labeled them as being non-valid in order to vote, which were IDs that mostly were carried by African Americans. So they struck that down. Other than a case like that, honestly, a lot of people don't even pay attention to the Court of Appeals because the judges up there very, very rarely see litigants. They see the attorneys that represent the litigants, but they don't see litigants. And most of the cases, 80% of the cases, if not 90% of the cases that are argued to the Court of Appeals are only argued by 3. So you've got these judges in session once every 2 weeks, once every 3 weeks, and they hear about 9 to 12 cases in that 1 week as a 3-judge panel. 1 to 3 of those cases will be picked for oral argument, and if those cases are picked for oral arguments, then the lawyer on each side of that case will come up. They get exactly 20 minutes and not a minute longer to argue their case. To be honest, they really don't get to an argument because those 3 judges are shooting questions at them. And then after that, it takes about maybe 2 months for the judge that's assigned to write the opinion Those 1 to 3 cases, those other 8 to 11 cases or 8 to 10 cases that are not picked for oral arguments, the judges go home, they read the briefs, they come together, they talk about it, they talk about the law, they talk about what they're going to do. The judge that's assigned to write an opinion writes an opinion, If all three judges agree, that's where it stops. If one judge dissents, that judge will write a dissenting opinion, and that case then has an automatic right of appeal to the Supreme Court. But then, as you know, even though you get an automatic right of appeal, the Supreme Court picks and chooses which cases they're actually going to hear.
Mm-hmm. Wow.
So it's a lot to take in, but if you don't have the Superior Court experience, or you've never had any experience arguing cases to the Court of Appeals, which I have had. I was an appellate lawyer at the Attorney General's office. If you haven't had that experience, in my opinion, it is going to be hard to actually decide cases on what the judge did wrong. If you've never written jury instructions, it's hard to know what would be the proper jury instruction and what wasn't. What wasn't. If you've never done those, motions to suppress evidence and had to actually go through, those are complex motions that sometimes it'll take all day for lawyers to argue why evidence should come in or why it should not come in. So while there's a learning curve, no matter who comes on the bench, experience matters. And to be honest with you, once I get elected, now keep in mind I said 80% of the cases that come up there are going to be criminal cases. 90% of the cases that go to the Court of Appeals are going to be cases from the Superior Court bench. Once I get elected, I will be the judge on the Court of Appeals that has the most trial court experience.
Wow.
And out of 15 judges. And a lot of people, a lot of your voters, because you don't see litigants go to the Court of Appeals, you just the attorneys go. They really don't pay attention until there's a major decision that comes out. But 80% of the cases that are heard at the Court of Appeals will stop at the Court of Appeals, and they will become what we call case law. And all cases are either decided on the statute, North Carolina general statute, or precedent, which precedent is just another word for case law. And so if I make a decision and I'm the judge assigned to write that opinion at the Court of Appeals, it may not be your business case today, but if you have a business case in the future and all three of us judges concurred in that ruling, that's going to be a law that's going to be applied to your business case. So you may not be the litigant in court today, but we definitely are going to affect your life because we touch almost every issue that comes.
Wow. That is a lot of information I'm learning as you're talking. So it's almost kind of like a check and balance for the actual lower courts proceedings and how they went through and ruled over that particular case. It's not really an appellate court for the actual litigant or the actual defendant if they felt like they got, unjustly, served or whatever their, punishment was. It's really how that proceeding took place and whether the judge.
Right.
And, wow, that's very interesting.
If a litigant thinks that they might have got an unjust sentence, then they can. A litigant has the opportunity to file what we call a motion for appropriate relief, and in that instance, they would allege that they had ineffective assistance of counsel because what they would probably say is, my sentence, I had cruel and unusual punishment, and it didn't justify the crime that was committed. And if it's a civil case, they'll say the monetary. All civil cases are about money. And so if it's a civil case, they'll allege that the monetary award was not justified by the evidence that was presented. And my attorney didn't argue that. And so it is the Superior Court judges that first handle those motions for appropriate relief. And we do that also by brief. So once we get the brief from whoever is filing that motion for appropriate relief, and then we get the answer from the opposing attorney, then we decide whether that case should come back into the Superior Court and there should be a whole new trial, or if something, if maybe something else could happen, like if it's a criminal case, maybe that case can come back in and the sentence could be modified. If it's a whole new trial, then of course they will strike everything that former attorney did, and the case starts from square one.
Wow.
Good.
There's so much information that I don't think regular citizens know that.
They don't.
Oh my gosh. Yeah.
They really don't. And that's why people are shocked to hear that, well, maybe they're not shocked to hear, but every presidential election, there is a 10 to 15% drop off from people who will vote for the president and then go down the ballot and vote for the judges. And that's because, honestly, folks that don't have frequent encounters with the court, they're like, I don't go to court, I don't know the judges, I'm going to skip those races.
Yep.
Folks that have frequent encounters with the court, they know all about it, they know our character, they know our judicial philosophy, but a lot of them don't vote.
Yeah, that is exactly what we're trying to break and trying to get this generation to not do. And we're actually encouraging, don't vote party, vote for the person.
Right.
And I know you mentioned at one point, really part of what you do is you take work home and have to review.
Seems like a huge amount
cases.
You probably work on at home as well.
How would you?
There is, like right before, I was 1 minute late, I believe, from calling you guys because I am sitting at home, but the Texas just walked out. So Superior Court judges, we are also those warrants that you hear of called trap and trace, which is warrants to intercept live conversations and intercept text messages, warrants to go to someone's house and search, warrants to do a forensic, what we call a forensic on the phone, which is sending it off to a tech company and getting every single piece of information, including what people think that they have deleted. All those things are signed by Superior Court judges, and we have to go through a kind of a very small, informal procedure in order to make sure that there's probable cause for us to sign that to allow people to basically invade somebody's privacy in that kind of way.
Wow.
Yeah, so these things are they're never ending. The Court of Appeals is called the working court because that is the court that really works the hardest and has the largest amount of caseload. And I love, Meredith, what you just said about trying to make sure that our voters don't vote party, but vote for people. One of the worst things that could have happened, in my opinion, for judges is that we were made to run based on our party affiliation. And, I keep trying to convince voters that, yes, I want you to vote for me. Yes, I am the Democratic nominee, and I am a proud registered Democrat. But I am not a Democratic judge. I am an independent judge whose rulings are based on facts and the rule of law and justice, period. It doesn't matter who you are, what you look like, who you love, who you don't love, who you hate, even if you hate me, just because of the color of my skin, or because I'm a female, or because I'm a judge. You still deserve equal justice when you come into that courtroom.
Right.
And what I have, my two last elections for district court and superior court were local right here in Greensboro, but this statewide race, it will inform you of how married to party people are. Because they, the things that people comment on my Facebook or my social media pages when I put up something concerning my race, it's all based, never met me, never seen me, never been in a courtroom to see how I hold court or how I treat people. It's all based on the fact that I'm a registered Democrat.
Wow.
And the worst thing about that is that, people think that as a judge and a registered Democrat or a registered Republican, that you automatically buy into every ideal and concept. But whether you do or whether you don't, that's neither here nor there when you're sitting on a bench. And partisan politics play no role in the judiciary. And if we don't do anything else in the future, we need to get party politics out of the judiciary.
That doesn't make any sense to me that two judges would have to run on a platform of either Republican or Democrat. That seems counterproductive to what the purpose
of the job
is. So that's very strange and weird that would be necessary. Wow.
Well, that was put in place. It's gone back and forth in North Carolina depending on who holds the majority or the supermajority in our state legislature, and it was that way, put in that way some years back for Supreme Court judges, North Carolina Supreme Court judges, but for the Court of Appeals and District and Superior Court judges, it was nonpartisan. In 2015, Governor McCrory signed the bill into law that went into effect in 2016, saying that now all judges on all levels have to run and designate their party, and also took away what we call public financing, which was for statewide judicial races like the Court of Appeals and Supreme Court. Whatever you raise, public financing would match that. Now, the issue with that for me is because it was designed, to me, in my opinion, to keep some folks out, which to me doesn't allow for diverse representation of that represents the diversity of our state. And it was possibly an attempt to make sure that only folks that had some good financial assets and could possibly self-fund would be able to run for these positions, because for judges, as far as like donations, 90% of our donations are only going to come from lawyers, because they're really the only ones that really care about who's on the bench. That they see all the time. And those lawyers are not only given to all the judges that are running, they're also, given to your congressional and your executive candidates that are running, your council of state that are running. And so if you don't have the money to self-fund, which most of us do not, just to be honest, we do not, it just seems like a way to knock you out. And that seems to me to, again, be counterproductive to what the judicial system is supposed to be about, because everyone in our state should feel like that they are represented in our branches of government. And if you keep moving the goalposts, then, we still end up with a system of leaders that come from one side of, for lack of a better word, the track. And then, those of us who want to be leaders that don't come from that side of the track, we're basically in our I guess politically correct way blackballed from getting in. And then, it's a vicious cycle that we need to change.
Right. Man, I agree. Well, we're going to take a little break. You were just blazing through any questions that I had prepared or written down. You were just hitting everything. So let's take a little break, and we'll get right back into this.